Ladies and gentlemen, welcome back to the People's Law School, an effort by the Alabama Association for Justice to present to you the best lawyers in America. Tonight, we have Kerri Riley. Kerri will be talking to us about a very hot topic, sexual harassment. And only Kerri Riley, I want you to know, she's probably the foremost expert in said subject. She's the only lawyer I know who's actually gotten a sexual harassment verdict in North Alabama in state court, and that's a very difficult thing to do. Kerri Riley is Huntsville's own. She grew up right here, was the valedictorian of her high school class, went on to the University of Alabama where she got her degree in chemical engineering before she went on to the law school at the University of Alabama where she obtained her law degree. Thereafter, she practiced law for a little bit in Jasper, Alabama, and has been here in Huntsville. At one time, she was the acting city attorney and has tried cases of all types and been successful. She specializes in defective products, car accidents, truck accidents, on-the-job injuries. She does divorces, domestic work, and but sexual harassment is the one, and I would say she's the best at it. She knows exactly what the procedures are, and they're very difficult, and an area of the law that have grown up over the years in the employment industry. When I got out of law school a few years ahead of Kerri, I didn't even think about even considering employment law, because the law was this: you could be fired for a good reason, bad reason, or no reason, and basically, as an employee, you didn't have any rights. Well, that area of the law has developed, and Kerri's going to talk to you about it. It is my honor and privilege to present to you Ms. Kerri Riley.
Thank you, and thank you for having me back again this year. I always enjoy it, and I hope we have a good time tonight and maybe learn a little something too. Last year, I tried to change things up just a little bit, and I talked about some of the other aspects of Title VII, some of the other types of employment cases that are frequently brought under Title VII or the Americans with Disabilities Act, age cases, race cases, religious discrimination. We talked about the Lilly Ledbetter, which was the new age discrimination case out there. And by the time I got nearly to the end of my talk, I was nearly to the end of my time, and we didn't get too much to the sex harassment aspects. And I heard nothing but complaints. It seems to me this class likes to hear about sex. So tonight I will have you know it's sex harassment, and more sex harassment. Which leads me to my disclaimer. This is not necessarily a family talk or a family lesson, so if there are young children watching, better go get mom and dad. I'll try to keep it clean, but the nature of these cases, when we talk a little bit about the specifics, can get just a little bit racy. Certainly nothing that I would want my 8-year-old son to listen to. All right. To review just a little bit, how many of you have been here year after year after year? Let me see a show of hands. All right. Well, for you all, this will be a review, but there are some here who are new, so I'm going to go over just the process and procedures of bringing a Title VII case in federal court. Title VII being that federal statute that prohibits discrimination based upon age, race, sex, national origin, religion, and etc. I always leave one out, disability. I left that one out. Title VII is a statute that's been around a while, but the courts continue to change it through their decisions, to interpret it, to broaden it, in some cases recently to make it more and more difficult to bring a discrimination case. But in order to start that process, you must first file a claim with the Equal Employment Opportunity Commission, and for our area of Alabama, it's located in Birmingham, Alabama. I know they have a website. I'm sure there's a form, although it is a good idea to have someone assist you, because there's some things that you have to put into that form to give you the best chance of having a successful lawsuit down the road. First, you must file the claim, and you have to do that within 180 days of what's called the adverse employment action. I tell my clients that's the really bad thing that happened to you. There can be some tricks to determining the actual day of the adverse employment action, so it's a good idea to do it sooner rather than later. And for those of you who might be a little math challenged, 180 days is less than 6 months. So that's something that has caught plaintiffs from time to time. First, you file the charge. Then the Equal Employment Opportunity Commission has an opportunity and a duty to investigate that charge. They contact the employer and they get their side of the story. They keep that claim for a minimum of another 180 days. And during that time, the government has the chance to investigate. They may mediate. They may try to conciliate the charge. They also have a right to take over the case from you as the plaintiff or from your lawyer, who may be assisting you at that point, and to bring a claim against the employer on behalf of the United States government. That rarely happens except in large class action lawsuits. So you file the charge, let the EEOC do its thing for 180 days, maybe give them a little information if they ask for it. And at the end of that period of time, the EEOC makes a determination. Now, most of the cases, the overwhelming majority of cases that I see have a determination that the EEOC cannot decide one way or the other whether or not discrimination has taken place. And usually that's because there's a fact dispute. And the EEOC is not set up to judge the facts. Occasionally they issue a cause finding, which is the EEOC finds cause to believe that discrimination has occurred. And you might think that's great. That's a good thing for a plaintiff. Well, it is. It's admissible before a jury. But it's not an open and shut thing. Plenty of cases with a cause finding have been lost at the end of the day. Occasionally, the EEOC will issue a no cause finding, meaning they've investigated and find no cause to believe that discrimination has occurred. Again, that's not the be-all and end-all, although a prudent plaintiff's lawyer will look into that one very carefully before they file a lawsuit for someone. Plenty of cases with a no cause finding have turned out to be plaintiff's verdicts in the end. So you might wonder what purpose the EEOC really has at the end of the day, and that's a good question lots of lawyers ask. We have to live with that. Now, at the point in time where the EEOC makes its decision, they issue what's called a notice of right to sue to the person who brings the claim, and that's where things really begin. You have 90 days after the issuance of a notice of right to sue to bring a lawsuit in federal court under Title VII for discrimination, or your rights are lost. That's when the clock starts ticking. Now, what type of proof do you have to have for a claim under Title VII? And let's talk about a sex harassment claim now, because that's what we're going to talk about for the rest of the night. What type of proof do you have to have? Well, first of all, you have to belong to a protected group. And that would be an old person, a disabled person, or in case of sex claims, it can be either gender. But it has to be some protected group. In sex harassment cases, then you have to have some proof of an unwelcome sexual harassment. Now, unwelcome is a key word. Sexual banter between people who think it's funny, touching between people who think that's okay to do. You may see it as an objective observer and say, well, that's sex harassment, you can't do that. But if it's not unwelcome, then it's not illegal. I mean, your employer might fire you for it, but as between the two people, it's not illegal unless it is unwelcome. It has to be based upon sex. The unwelcome act, the unwelcome conversation, whatever it is, has to be based upon your sex. If you're making the comment, but it's not because of your gender, for example, because you're a woman or because you're a man, or because you're a gay man or whatever. If it's not because of, then it's not actionable. Somebody's got a question, and I'm going to try to remember to repeat the questions.
Can a third party complain about two other parties, like a man's hitting on a woman, and a third party complain about sexual harassment?
Okay. The question is, can a third party complain about sexual harassment and then I guess bring a case based upon two other people's behavior that they're having to witness? And that's a good question. I actually get that question a lot. And I'll address it a little bit, or try to, in the context of a new case we have this year to talk about. But as most of these cases, and most of my answers will be, it depends. If someone is being forced to observe really extreme behavior, and I won't go into what that means, but you all can use your imaginations, then I would say that it is likely actionable if you were being forced as a term or condition of your employment to watch two people engage in pornographic behavior or something like that. You might have a fact situation there that could give rise to it. If you're asking about favoritism, which is how the question is usually posed to me, the boss likes this one better, and she gets all the raises and promotions because she lets him put her hands all over, all over her, and I don't get a raise because I stand my ground and I don't allow that. That is usually not actionable. Doesn't seem fair, doesn't seem right, and it seems very stereotypical, but that whole sleeping your way to the top thing is not usually actionable for the third party observing it. Does that answer your question? Yeah. Okay. Behaviors which are sexually harassing behaviors must be severe or pervasive enough to alter the terms and conditions of employment. And that's where the cases have turned, and that's where the plaintiffs have increasingly been squeezed until it's become more and more difficult to bring a successful sex harassment claim in the federal courts. The courts there's a line of cases where the courts talk about what it takes for sex harassment to be severe or pervasive. And what you and I would normally think, and a whole lot of my potential clients that come in the door think would be actionable, actually is not. It's not enough under the law to be severe or pervasive. And that has to, of course, create an abusive working environment. It not only has to be subjectively severe or pervasive, meaning I think it is and you think it is, but it has to be objectively severe or pervasive, which means that the court thinks it is. And the courts allow a lot of behavior that you wouldn't ordinarily think. Now, just to illustrate that, the what is and what isn't under the current standard state of the law. Case called Mendoza versus Borden, and it's sort of a leading case in this area. And these were the facts in this case, and I'll tell you at the outset, this was not enough to bring a sex harassment lawsuit. Constant following and watching with the up and down eyes. Some people call them the elevator eyes. Do you know what I mean by that? You know, the woo-hoo, that kind of thing. Not enough. Staring at a woman's private areas and making sniffing sounds. Also, not enough. Touching, yeah, it's disgusting. I hear some rumbling in the back going, there ought to be enough, and I agree, that ought to be enough, but it wasn't. Touching the shoulder, rubbing hip areas together, a sexual comment, along with the sexual comment with a hip rubbing of, hey, I'm getting fired up, not enough, okay? So what do the courts say is enough. And they have given us 4 factors in another leading case to help, well, really to help the court determine objective reasonableness, because these cases are just very fact-specific. One factor that the courts look at is the frequency of the conduct. Does it happen once in a while, once in a blue moon, or is it an everyday, all-day type occurrence? The severity of the conduct. And again, I'll say, just from my way of looking at it, the courts are pretty jaded when it comes to severity. Things that I think are severe, courts don't necessarily think are very severe, and we'll talk about a few more examples. Whether the conduct is physically threatening or humiliating. Now, there's one, if it's physically threatening, if someone is restrained, if someone is pushed in the back room and prevented from leaving, that kind of thing. Now that kind of thing the court does not tolerate very much. Whether the comment is humiliating or merely offensive. Well, what does that mean? And whether the conduct unreasonably interferes with someone's job performance. But again, what the court thinks is a reasonable environment for someone to be able to function in, and what people can really do might be 2 different things. Now, a case that is fairly recent, 2008 case, Torres versus City of Sanford, Florida, and that's an 11th Circuit case, which means all these cases I'm going to talk about are 11th Circuit cases. Do you all remember, or have you been taught this year where we are in terms of national law? The federal courts, of course, we have the United States Supreme Court. They're the final word. And then we have several circuits, jurisdictions, divisions within the United States, where we have appellate courts that decide the law. When, say, I try a case down here right on Home Street, the federal court, and that case is appealed, then it goes to an appellate court. And our court, which covers Alabama, Florida, and Georgia, is the 11th Circuit Court of Appeals, and we have, I forget how many circuits, at least 11 though, because we're the 11th. And that sits in Atlanta. And then when there are different, say the 11th Circuit says the law is one thing, and the 5th Circuit says it's something else, and the 2nd Circuit says it's something else, then eventually somebody appeals that little area of the law to the United States Supreme Court, and they decide. But until the United States Supreme Court speaks, and frequently they don't speak until there's a body of law out there in the various circuits and all the various aspects of the law have been explored, and until there's a conflict, law is different in California than it is in New York, for example. So frequently the Supreme Court doesn't speak. So until they speak, the 11th Circuit is our law in the state of Alabama. And the cases I'm going to speak about today are 11th Circuit cases. So, a recent case on what was severe and pervasive, severe or severe and pervasive enough behavior that a plaintiff could bring a lawsuit and actually try that case to the jury without getting thrown out by the judge, was Torres versus City of Sanford. In that case, based upon the totality of the circumstances, everything, which included daily phone calls, simulation of sex acts, asking on dates, private conferences with the boss, turned into personal conversations, threats about telling. If you tell, I'm going to fire you. If you tell, nobody will ever believe you. If you, that sort of thing. Physical restraint, I mentioned that one. And again, this sniffing thing, which I don't quite get, but deliberate smelling, the court said that was severe and pervasive enough conduct that this plaintiff got to try her case to the jury. Has anybody talked to you about the conduct of a lawsuit? What it takes from the beginning to the end to actually get to the point of trying that case to the jury? Yes? Yes? No? Okay. Well, very briefly, in a sex harassment case, because that's what we're talking about today, get your notice of right to sue, got 90 days, file what's called a complaint, which says this is what they did, it's illegal, it's against the law, I was damaged, I'm entitled to a verdict. I mean, that's a layperson's description of what's in a complaint. The lawsuit proceeds through a process called discovery, when you get to, the plaintiff gets to ask the employer questions, ask documents of the employer gets to do the same of the plaintiff, and then there comes a point in the lawsuit when all of that information has been exchanged, all of that discovery has been exchanged, and the defendant tests the case in front of the judge for the judge to decide if that case can go to a jury. And that point is called summary judgment. And it's where the plaintiff has to put up all of their facts, their best facts. The judge is required to believe any factual dispute in favor of the jury, in favor of the plaintiff, excuse me, have to believe that the jury would find that fact in favor of the jury, in favor of the plaintiff. I've said that twice and it's still wrong. The judge has to believe the plaintiff's version, in other words, and then the judge applies the law, and you either go to the jury or you're not. If you lose on summary judgment, that's when cases get appealed to the 11th Circuit. If you win on summary judgment, you get to go try the whole case now for real in front of a jury. They either win or lose. So when we're talking about these cases, we'll talk frequently about cases that got appealed to the 11th Circuit because they got thrown out on summary judgment. Plaintiff never got to try their case. And then the 11th Circuit either says, oh, yes, they can, or no, the judge was right. They don't get to try that case. It's not good enough. Yes, back here.
You made a comment in passing there that sounded critical, and the reason I'm mentioning this is that I had a case where the question of when the period of being able to start the action, I think you said 60 days, and 60 days from when?
90.
90 days, okay.
90 days from the notice of right to sue. 90 days from actually the receipt of the notice of right to sue by either you or your lawyer if you have one.
So from the date of the allegation, it's not 90 days?
No. From the date of the allegation, you have 180 days to file your charge with the EEOC in Birmingham.
That time becomes critical. That's why I was asking, when does that 180 days start?
It starts from the adverse employment action, which is usually the bad thing, okay, the bad thing. Now, you just asked a question. It's a good question. The question was, when does the adverse employment action, when does that occur? Is it the most recent one? That's a really good question, because it may not be the most recent one. In order to properly try your case, you may have to go back and pick up, if there's a series, you may have to go back and pick up an earlier one. Now, in sex harassment cases, usually if it's a continuing pattern, then you can count from the last one, okay? But when I say continuing pattern, it better be a daily, nearly daily sort of thing, or the courts are likely to find that these were discrete acts. If you've got discrete acts, then you better count 180 days from the first one. Better to be safe, earlier better than later, better to be safe than sorry. And we haven't talked about state court, but Alan mentioned it because I have tried some sex harassment cases, essentially sex harassment cases, in state court. The statute of limitations in state court is 2 years. So there are two really good reasons to try cases in state court. One is that the employer is not big enough to trigger federal protection. If there's not 15 employees, then Title VII doesn't apply. Have to be at least 15 employees, or the employer is not covered under Title VII, and they can do whatever, do whatever they want to do that is not illegal under state law. So if you have 14 or less employees, you go to state court or not at all. The other reason is if somebody misses their 180 days. Then in state court, you have 2 years. but there is no such thing as a state court sexual harassment claim. You're basically bringing the facts of a sex harassment claim under a common tort law, the same kind of state law that you use for car wrecks and such as that. Someone's intimate space, or it's an outrage claim, which is conduct that's beyond the bounds of decency and utterly intolerable in civilized society, and it's got to be pretty bad to make an outrage claim. Or it can be a claim of negligent hiring. If you hire a known sex harasser, negligent supervision, negligent training, or negligent retention. If you keep an employee that you've subsequently learned is going to sex harass people. Those are state claims, and they're frequently brought along with a federal claim in federal court, so you bring both. I'm skipping around here a little bit in response to your question, but one of my little star notes here is to explain some of the differences between state and federal claims, and why you'd bring one in federal court when you have Title VII. Sometimes certain claims are just a little bit easier under state law. Sometimes they're a little bit easier under federal law. Of course, in federal court, your lawyer, if they're successful, can reverse attorney's fees. But the state claims do not have that protection. If you were to get a verdict in state court, then you've got to split your verdict with your lawyer. So we try to keep them all in if we can. And the damages are different, which I'll go over that a little bit in a little bit. Anyway, picking back on where I was on the severe and pervasive. I think the last time I spoke about sex harassment was the first time that I had a case to talk about where we had man-on-man sex harassment. Now, do any of y'all remember that? Do you remember that male-on-male sex harassment is actionable as well as male-on-female or female-on-male? Well, we had a case, male-on-male, and let's see if I can tell you the facts of that one, which were not enough, not severe enough and not pervasive enough. This was some years ago, and in this case, the boss took a magnifying glass out and examined the male plaintiff's private areas. Something tells me that was an insult, but I don't want to go there. Kissed him, and my note is stared at him in the bathroom, but it was a urinal checkout is what it was. Now, how many guys in here think that ought to be enough? Like all of you? It ought to be enough, right? Guess what? Wasn't enough. Pardon me?
I said a baseball bat would work pretty good.
Yes, and the comment was baseball bat would be an effective remedy, and I don't know that I'm going to dispute that. So we have a new case, another male harassment of male subordinate. This is a 2009 case, and I'm going to read you these facts, and then I'll let you all vote and tell me what you think, if this was enough or not enough to be severe or pervasive. Both subjectively, because obviously it was subjectively to the person that was happening to, but was it objectively severe or pervasive enough to alter the terms of this person's employment? This is Corbett versus Home Depot, and it was tried. And we have Lenny, who was the HR manager of all things, who purportedly began making inappropriate sexual overtures to two store managers, male store managers, Corbett and then a fellow named Raya. Lenny made repeated phone calls of a sexual nature as many as 12 times a week, inappropriately touched each of these two store managers. Said one of them was not his usual type, but he just couldn't stop thinking about him. That he would show him how to be gay and he would like it. That he liked this store manager's baby face, asked about his underwear, what kind he wore, or did he wear any, asked him if he shaved his body, asked him if he and his wife liked to swing, gave him gay websites to look up. He told the other store manager he was cute, his hair was beautiful, he liked his eyes. This is an interesting one. He was the Italian heifer that I like. And asked him out, on dates and such as that. Isn't that charming? I think that's charming. He gave them personal massages, commented about their hair, played with their hair, hugged them. How would you like to be a store manager and have to go to corporate HR with this kind of thing going on? Put his hand on one of them's leg, pressed his body against him in the old private-to-private grind, snuck up behind one of them and rubbed his stomach, pulled him into a hug, cuddled his head back, neck, and shoulders, and said, maybe we can do this some more later. Anyway, they reported the conduct, obviously, to someone else and got fired. Both of those store managers got fired. One got fired for retention and use of a company's cell phone. One got fired for taking some improper markdowns. Now, remember we talked about the case where when it was male on female, they looked at the totality of the circumstances to see if it was severe or pervasive enough? How many of you think the totality of the circumstances say this is severe enough, pervasive enough that these guys should get to go to the jury? Let's see. Okay. All the men, most of the women. Anybody who does not think it ought to be enough?
Can I pose a question?
Yes, you may. You may.
What about the criteria for being unwelcome?
Well, it has to be unwelcome. And these fellows clearly were complaining. Okay? They did complain. Then they got fired. Okay? Yes?
Does being fired make it a different circumstance since they were fired for what went on?
The question is, since they were fired, does that make it different? And we haven't talked about that yet, but there is sex harassment and then there's retaliation. The firing then was a claim was brought for retaliation. Because I complained, I got fired. And that is a separate type of claim. That's a separate type of claim. What my question was, how many of you think that this is enough for a sex harassment claim? And of course, it sounds like it's enough for a retaliation claim, and I'll give you a hint, it was. But is there anybody who thinks it isn't enough? Well, that would be anybody except the 11th Circuit Court of Appeals, because guess what? Not enough. Not enough.
What if they have tape recording of all of that?
We, in deciding whether this was enough or not enough, the court presumes it's true. The court presumes it's true. And presuming all that was true, the case got thrown out, did not go to the jury, was not allowed to go to the jury. Now,
Excuse me.
yes?
What would happen if the victim actually tried to defend himself against something like that? Could that go against the victim? If he was approached, if he was grabbed and done something, and he punched his lights out. What would happen in that case?
The question is, what would happen if the victim used the baseball bat remedy that was posed earlier? Okay? Punched his light out, whatever. Pardon me?
During the touching, not in the parking lot.
Yeah, not afterwards, but while it was happening. Could that go against the victim? Could the victim be fired then? And the answer to that is yes. That would go against the victim. Yeah. Yep. I know. And the only good thing about this is I haven't said this tonight, but I've said it before, and some of you may remember, often the retaliation claims are better cases, easier to bring, easier to win, than the underlying sex harassment case. And that was true in this particular case. The 11th Circuit said, well, it's not severe and pervasive enough, but we will let the retaliation case go forward. We will allow these two men to try to prove that the reason why they were fired was not for inappropriately taking markdowns on contractor discounts or something of that nature and or keeping the company cell phone. It was really because we complained about this HR manager and he signed off on the firings, and he did it because he wanted us gone because we complained about him. So that case will go to trial on the retaliation.
Can they bring forward the evidence of all those occasions in the retaliation case?
Well, and that's another good question. The question was, can you bring forward the evidence of retaliation, the evidence of the sex harassment in the retaliation case? And the answer is yes, you can. Yes, you can, because you get to prove what you retaliated against for. So the jury gets to hear it all. That's why I like retaliation cases. They're not as hard. Okay. What? Yes.
Did the manager get fired that was perpetrating all this?
The HR manager. We don't know.
Oh,
He had not at press time. At press time, he was not fired.
he should be fired.
Yeah. Oh, yeah. All right. So we have one more. Brand new case, January 20th, 2010, Reeves versus C.H. Robinson Worldwide, 11th Circuit case. And this one really comes with a disclaimer. I've written raunchy language, but raunchy does not even begin to describe it. The plaintiff had worked on a container ship. I don't know if you all know what that is, but this is a case out of Mobile. And it worked on the seas and in the merchant marines. And this is a female plaintiff. So let us just say for shorthand that she was not a princess. She'd been exposed to rough language. She'd worked in a male-dominated environment. She said a few words herself from now and then. If she dropped something on her toe, she was certainly not a princess. She worked in she was the only woman. And she worked for a shipping company. Now, the language that was used in her work environment was never directed specifically at her. And we're getting back to your question, okay? Previously, in all the cases I've read, unless the offensive words, offensive comments, offensive actions were actually directed at the person complaining, then you couldn't bring a case. I hadn't seen a case that you could until now. None of the language that this lady heard, none of the things she saw were specifically directed at her. And the courts have repeatedly, over and over, said Title VII is not a civility act, rude and boorish behavior, if it's directed equally toward men and toward women, and it's just the environment, it's just something you have to put up with. We've seen this language over and over and over in the cases. Well, in this case, it seems that there was one adjective and one adjective only in this work environment, and that began with an F and it ended with an ing. So that tells you something about, and this is everybody she came in contact with all day long. Women, the best name for women in this environment begins with a B and rhymes with witch. And it goes down from there. All other terms to describe women were sexual part terms. Let's just put it that way. Everything from describing who was on line 3, if it was female, it was ugly. The jokes were rough. There were sexual jokes. These folks told jokes all day long. They were always sexual jokes, and they were rough sexual jokes. Apparently, the only topic of conversation in this whole business was sex, and it was always ugly to rough. Acts were described routinely that were not mainstream. The men viewed pornography on their computers. That was rough. How old are you? Did I make the disclaimer at the beginning? And okay, you get the drift. I mean, this is bad stuff. It's not the old 25, 30 years ago airbrushed, Playboys. Something really, really rougher than that. And but it was never directed at this woman. Now, she complained. She started complaining to her coworkers. That, hey, that's just more than I could take. Then she moved from her coworkers to her supervisors and all the way up to the chain. She complained and she complained and she complained. And it was well known that she complained. It was so well known that when a person was going to leave that employment, he told her the night before, the day that was to be his last day of work, for her to, Ingrid, bring your earplugs tomorrow because I'm going to turn this place blue. They all knew she couldn't handle it. And eventually she quit. Now, the question was that such a hostile environment that she was entitled to quit, even though none of that was ever specifically directed at her? It was never, Ingrid is a, or she was never called ugly things herself, although she did walk by the horrible pornography and see that because it was just in her face. And what do you think? You think it's enough?
Vote.
Yeah, let's vote.
Question.
Think it's enough?
Was she pressed or enraged to quit, or was she allowed to quit of her own accord?
She quit of her own accord.
That's the question. Was she entitled to quit?
The question is, was she entitled to quit under those circumstances?
Because of those situations.
Because of that situation.
Not
Never.
because of her performance or whatever.
She quit. Could she quit and then sue for loss of a job, for constructive discharge, because that environment was so intolerable that she had a right to not have to work in it?
Did you not say that she was using language herself?
She used mild language.
My language.
I mean, mild profanity, not vulgar. She didn't use vulgarity. Some mild curse words. 4 letters.
It was a hostile environment, but it wasn't sex harassment, I wouldn't think.
The comment was it was hostile environment, but not sex harassment. And I would agree with you that up until this case, that was probably accurate. Okay. Yes.
Wouldn't it be sort of almost under the Gender Equality Act, since she was the only woman there, and therefore be somewhat entitled to some niceness?
The comment is because she's the only woman there, doesn't that help her case? Wouldn't that make her entitled to sue and not have to listen to all that? Okay, let's vote. How many think it was enough? How many think it wasn't? First, enough. How many think it's enough?
She had the right to quit.
How many think she had the right to quit and sue? About a third. How many think that the law would not allow her to quit under those circumstances?
Wait, one question before that. Was she considered one of the boys?
Was she considered one of the boys? I don't know.
You'd have to ask the boys.
You'd have to ask the boys. That's a good question. I would say it's about a third that thinks she was entitled and about 2/3 not. And guess what? The court said she could bring her case to the jury. That's what the court said.
What was the ground? Was it hostile environment or sex harassment?
It was because of the disparate treatment, which is hostile environment, based upon her sex. It was so outrageous. And one thing I saw that the court went off on was they used creative vulgar blasphemy. If you all can think of a vulgar blasphemy, and the court really kind of went off on that and said, I thought it was a Bible Belt comment. Frankly, it might not have been the way the law might have not fallen that way in a different circuit, but in our circuit, that seemed to be the straw that broke the 11th Circuit's back and allowed them to go to the jury on this one. Yes.
I don't know how to put this, but Was the environment there before she got hired, or did it start after she got hired?
The question is, was the environment there before she got hired, or did it start after she got hired? And that is a good question, because it goes to, was this just how it was, or was it directed at her? And the answer to that is, that's how the environment was. And she was the first woman hired into that environment, and the courts basically have said she can try her case on whether that company, once they hired her, had to clean that environment up. Question.
Comments. Anybody can quit, anybody can sue. Now, so the question is, has she won the case? And the second point is, did you see this week where the Navy female captain was fired for the same thing?
Whoops.
Okay, the question is, has she quit? I mean, has she sued, and what happened? And I don't know. I don't know, because this is a brand new case. It'll get sent back down, and then it'll get tried or settled. It could get settled at this point. Just not summarily thrown out. This case has probably been going on about 4 years by now, and it will keep going.
Were they at sea?
The question is, were they at sea? And no, this was in Mobile, as I understand it. Okay, any more questions on that? All right. And then it looks like my time is getting very short, but I have one new interesting case that's an Alabama case. And I mentioned that some cases are brought in state court utilizing state laws to present the sexual harassment facts to a jury, because we don't really have a sex harassment statute in Alabama. And when those cases are brought, one of the things that the defense lawyers always try to do is they always try to ask all about the woman's sexual history. And you know, they just want to know everything that you ever didn't want to tell about your life. If you open yourself up to that by becoming a plaintiff. And of course, lawyers like me always protest and will stop the deposition when those questions are asked and say, oh no, you're going to have to get the judge to rule on that one, because I'm not going to let my plaintiff answer that question. There's no point to it. So that happened, and the decision let's see, the trial court denied the motion, and the plaintiff sought a writ of mandamus. That means the trial court said no, the plaintiff had to answer the question. So it went up to the Alabama Supreme Court, which is, of course, the highest court in our state. And what do you think happened? Do you think the woman had to answer those questions or not before our Alabama Supreme Court? Who thinks yes? Who thinks yes?
Yes.
Who thinks no? Well, the yeses have it. Our Alabama Supreme Court, in its infinite wisdom, said those questions were relevant as to how offended the lady was. It was relevant to damages. And there was a lone dissenting vote. That was our Chief Justice Cobb. That would be Sue Cobb, and she is not a boy named Sue. And she said, no, I don't think she should have to answer, but she was outvoted by all the rest. It is right at 8:30. I haven't gotten the 5-minute sign. I've got 10 more minutes. Good job. Okay, then I'll take a question.
Mine is not about the sexual harassment. I was hoping or wondering if you could address the fact that Alabama is an at-will state and the employees, is that changing, Mr. Brinkley, allowed to the fact that that might be changing? Do employees have any rights at all in Alabama?
The question is, the request was, could I, excuse me, I'm going to sneeze, I think. Maybe not. All right. The question was, could I address the fact that Alabama is an at-will state, and is that changing? And as Alan said when he was introducing me, Alabama is historically an employment at-will state. That means that the employers have rights and the employees don't. You can be fired for any reason, a good reason, a bad reason, a wrong reason, no reason at all, because you have green eyes, because you have blonde hair, because you have no hair. Any reason at all, except for You cannot be fired because you filed a workers' compensation claim. There's a special statute for that. And now Alabama has decided that you cannot be fired because of your age. So we now have an age statute in the state of Alabama. Other than that, you can be fired for any reason, no reason, good reason, bad reason, but not a federally protected reason. The states, our state, and our employers are subject to the federal laws as well as state laws if you have 15 employees. If you don't have 15 employees, then you can discriminate. I'm not advising it, but you can. I frequently see people in my office, and I have to explain to them that there is a difference between a moral wrong, and there are lots of things that are morally wrong, and something that is legally redressable. It's morally wrong, at least I believe, to fire someone because they're a woman, because they're disabled, whatever, and only because of that reason. I mean, nothing to do with their performance. But unless you have 15 or more employees in the state of Alabama, you can do just that. Question?
You use the terminology employee, since you're getting off on this particular topic area. Could you identify what is an employee?
What is an employee? I mean, as opposed to an independent contractor? Well, I didn't look that one up. What is an employee as opposed to an independent contractor?
My point being is
Yeah.
you can be laid off, so what's the difference between just telling you, I need your services today, but not tomorrow?
Could you say that one again, please?
Well, my question has to do with being an employee, that if they tell you, okay, come to work today, but don't come to work tomorrow, does the employee have any benefits or rights to that?
Oh, the question is, can an employer say, come to work today, don't come tomorrow, come the next day, don't come the next day? Does the employee have any general benefits or rights? Well, you know, they're gonna run afoul of unemployment if they do that. But other than that, you know, it has to be because of. There has to be a reason that's an illegal reason in order for it to be actionable. Yes.
How many states are like Alabama at will? What is the difference? What rights do employees have? And are there a lot of other states that are not at will states?
The question is, what's the difference between Alabama and other states, and what are those states called? They're called right-to-work states. And an employer must have a reason in a right-to-work state to terminate. Otherwise, the employee has a right to work. Now, since I'm not a lawyer in a right-to-work state, and my bar license is in Alabama, that's about as much as I know about that. The only other piece of that I know is that since we have a lot of transplants to Huntsville, people have come from different states, I do see a lot of potential clients who come in huffy and believing that, you know, they have a really good case because, you know, they've been terminated and the employer didn't have a good reason in their mind to do so. And they go out quite deflated when they find out that this is an employment at will state. And you know, that's really, really hard, in fairness, for people to understand. I've had lawyers send me their family members. And the lawyer will be on the phone with me going, yeah, I know it's an at-will state, but, you know, isn't there something we can do? And, you know, because it's just hard. I mean, it's counterintuitive. We really believe that we should be able to work if we haven't done anything wrong. And that is just not the law in the state of Alabama. Yes?
I'm kind of fascinated at this legal view of protected groups. Can you tell me what the law, you know, defines as a protected group?
What does the law define as a protected group? And it is a group that has historically been discriminated against in the workplace. And so the Title VII was designed to prevent and correct discrimination in the workplace as to that protected group. I know that we're all progressive, but it just really wasn't that long ago that women did not work outside the home. They were not expected to. Black persons didn't, you know, they could work, but if they wanted to get paid for it, or have any job that required an education. You know, they just weren't eligible. They just weren't hired. Disabled people were hidden away. So these are the situations that there may be some people in this room old enough to remember when that was just the way it was. And that Title VII was enacted in 1964 to correct that, and we're still correcting it today. I mean, it's not there yet. It takes a long time to change attitudes in the workplace. So I hope that answers your question. Yes, over here.
So you're saying in Alabama there is no contract between an employer and an employee. Therefore, as someone said, there is no employee if there is no contract between the employer and an employee. How do you know you belong to the company, or are employed by the company if there's no contract between the two?
The question is, in Alabama, there's no contract then between an employer and an employee, and the answer quickly is that there's no implied contract just by virtue of the fact that you go to work. They can fire you anytime they want to. And how do you know you're an employee? Well, you get a payday on Friday. We hope. One back here, and then I'll have to close.
Who decides the status of a state? Whether it's a right to work state or it's an at will? Is that something that's voted on a state ballot?
And the question is, who decides if a state is at will or it is a right to work state? And the answer is that the Alabama legislature. Alabama legislature decides. Okay.
Is there any move on to get it changed? Has anybody ever complained?
The question is there any move to get it changed? Has anybody ever complained? And I'd say I see a lot of people who complain. Okay, well, I've finished my time. I'll be happy to answer your question after, but I think I need to close now. Thank you so much for having me. I really enjoyed it. It was a great class, and thank you. More sex next year.
Good job.